Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
So, I had a family lawyer call me last week, genuinely panicked, asking if she was going to get struck off because she'd used ChatGPT to help draft a chronology.
Okay, was she?
No, but it tells you something about where everyone's head is at right now. Because on the 29th of May this year, Chief Justice Alstergren issued the first FCFCOA, the Federal Circuit and Family Court of Australia, practice direction on AI. This is the PDAI.
Right, and this isn't some optional guidance note, is it? This is binding.
Binding and immediate. It applies to lawyers, litigants, private experts, everyone. And here's the bit that trips people up. It applies to any tool that does something a human would otherwise have to do, whether or not anyone's calling it AI.
So my transcription software counts.
If it's doing something that would otherwise require human intelligence, yes. Drafting assistance, smart search, transcription, document management systems with AI baked in, all in scope. The label doesn't matter. The function does.
That's a much wider net than I think most practitioners are picturing.
It is, and that's exactly why we're doing this episode. Because by the end of the next 10 minutes, you're going to know what PDAI actually requires, what's flatly banned, and what you need to have ready if a judge turns to you mid-hearing and asks, "Did you use AI to prepare that?"
Which, apparently, they're now entitled to ask.
They are. Let's get into it.
Okay, so start with the big picture. What's the actual obligation here? Is it don't use AI, or is it something more nuanced?
Much more nuanced. It's not a ban, it's a framework. And it sits on 6 core principles under Clause 3.3. No hierarchy, all 6 apply, all the time.
Hit me.
Integrity. Your AI use has to support fairness, truth, proportionality, equality before the law. Accountability. You remain responsible for every document filed. Full stop. AI involvement changes nothing.
So the AI got it wrong is not a defense.
Never was, never will be. Third, accuracy. Everything AI produces has to be independently verified before you rely on it. And this is important. A paid commercial tool is not assumed to be reliable just because you're paying for it.
People do assume that though. I'm not using the free version, so it must be fine.
Exactly the trap. Fourth principle, confidentiality and data security. You need to actually understand how your tool stores and uses whatever you type into it. Fifth, safety. Don't use AI in a way that could compromise a court user or a child's safety, including accidentally leaking a protected address or medical records.
That one feels very family law specific.
Extremely. And sixth, education and understanding. Lawyers have to undertake AI training proportionate to how much they're using it, and the court will not accept "I didn't understand the tool" as an excuse for misuse.
So ignorance isn't a shield, it's actually part of what you can be pulled up on.
Right. Not knowing how your tool handles data is itself the breach.
Okay, let's make this practical, because principles are nice, but lawyers want a checklist. What do I actually do before I file something AI touched?
There's a pre-filing checklist, and I genuinely put this on a sticky note. Step 1. Verify every case citation and section number against OSTLE or the Federal Register of Legislation. AI tools fabricate citations that look completely legitimate.
This is the famous hallucinated case law problem.
Same problem, now with a specific clause attached to it. 4.7c. Step 2. Don't file AI output verbatim. Under Clause 4.7a and b, you must proofread it, adapt it, strip out anything that's overseas law or generic advice that doesn't fit your matter.
So it's a starting draft, not a finished product.
Always. Step 3. And this one's big for family law specifically. If AI helped draft an affidavit, you need to confirm the content still reflects the witness's own words, their own knowledge and experience. Clause 4.9 flags this as needing particular caution.
Because an affidavit isn't supposed to sound like a legal drafting assistant wrote it.
Right, it's supposed to be their voice. Step 4. If you're engaging a private expert witness, you have to give them a copy of PDAI and get written confirmation they've read it before they prepare their report.
Wait, that's the lawyer's job, not the expert's?
Yours. Clause 4.10 puts that obligation squarely on the engaging lawyer. If your expert hasn't certified they've read it and something goes wrong with their AI use, that's on you.
That's a real trap for the unwary. What's step 5?
Read your AI tool's terms of service. Does it retain your inputs, train on them, share with third parties? This varies not just tool to tool, but tier to tier within the same product.
So the free version and the enterprise version of the same tool might behave completely differently with your data.
Completely differently. And step 6, where you can, turn off chat history in any Gen AI chatbot you're using. Reduces the risk your client's data gets retained or reused outside the matter.
Okay, 6 steps. And I feel like most of them are just good practice generally. But now I want the sharper edges. What's an outright, you cannot do this, full stop, under PDAI?
4 hard prohibitions. 1. Never use AI to alter, enhance, or fabricate images, video, or audio being used as evidence. That's clause 4.6b, and honestly, that one should be obvious, but it needed saying.
Deepfake evidence, essentially.
Exactly that risk. 2. You cannot put discovery documents, subpoena material, or anything under a non-publication order into a Gen AI tool, unless it's a closed environment with enforceable confidentiality terms and a guarantee the data won't train the model.
Which rules out basically every free public chatbot.
Rules them straight out for that category of material. 3. No recording or transcription tools in the courtroom, AI or otherwise. And 4. You cannot use AI to perpetrate family violence or litigation abuse. Clause 4.20.
Meaning what, in practice?
Think AI-generated harassing content, fabricated messages, anything weaponized against the other party. It's a direct, named prohibition, which tells you the drafters were thinking about real cases they'd already seen.
Grim, but I get why it's there. So what's actually permitted? Because it can't all be prohibition.
No, and this is where I think practitioners relax a bit too much, or not enough, depending who you talk to. AI-assisted drafting of submissions, chronologies, research, all fine, provided a human verifies it. Closed or enterprise tools with contractual data protections and no training on inputs, encouraged. And here's an interesting one. Clause 4.14 actually encourages offering AI-assisted outputs to the other side if it reduces their manual burden and helps access to justice.
Wait, so you can hand the other side AI-generated material to help them?
If it genuinely promotes access to justice, yes, the court is actively pro that. It's not adversarial gatekeeping for its own sake.
That's a nice, slightly unexpected note in an otherwise pretty restrictive document.
It is. Now, disclosure. Do you have to tell the court you used AI?
I feel like this is the question every lawyer actually wants answered.
And the answer is no, not proactively. There's no general obligation to volunteer that you used AI on a document. But, clause 4.11, if the court asks, you must answer. Which tool, how you check the output, how you met the 6 principles.
So it's don't ask, don't tell, until someone actually asks.
Pretty much. And the practical takeaway is keep a brief AI use log for every matter. Tool, task, verification method, and expert certification where relevant. That log is your evidence if it's ever raised.
Can we make this concrete for a second? Walk me through how this actually plays out on a real file.
Sure. Say you're preparing an affidavit for a parenting matter, and there's a lengthy history of text messages you need to summarize into a chronology.
That's a classic tedious drafting task. Exactly what people reach for AI to help with.
Right, and that's fine in principle. Chronologies are explicitly permitted, but think through the principles as you go. Confidentiality are those messages which likely name the child and possibly a protected address, going into a closed tool or a public one.
So that decision alone determines whether you're even allowed to do this the way you're about to.
Immediately. Then accuracy. Did the tool summarize the tone and substance correctly, or did it smooth over something that actually matters, like a threat being softened into a disagreement?
Which would completely change how a judge reads it.
Completely. And then integrity and accountability. You're the one who has to be comfortable that chronology reflects the truth of what happened, not just a plausible sounding summary. If it goes in front of the court and it's wrong, nobody's asking the AI tool to explain itself.
They're asking you.
Every time. So it's not one checklist item in isolation, it's all 6 principles running simultaneously on one task.
That actually makes the framework click for me, more than reading the clauses in isolation.
That's the intent behind it, I think. It's meant to be a lens you apply, not a form you fill in once.
Let's talk public tools specifically, because I think this is where most risk actually sits day to day. ChatGPT, Gemini, Claude's free tier. Can family lawyers use these at all?
Not prohibited outright. But clause 5.4c says you must not enter sensitive or confidential client information into any publicly available AI system. And in family law, that's not just a professional conduct issue.
There's a criminal angle too, isn't there?
There is. Disclosing information that could identify a party, witness, or child in these proceedings can be an indictable offence under Part 14b of the Family Law Act. So typing "my client Jane, whose ex-partner has a restraining order" into a free chatbot isn't just sloppy, it can be a criminal problem.
That's a genuinely sobering line to draw. So the rule of thumb is, public tool, strip every identifying detail, or just don't use it for that task.
That's the rule of thumb. Closed, enterprise tools with contractual protections are a different risk profile, but even then, you still verify everything. A closed environment isn't a shortcut around accuracy.
Right, closed just protects confidentiality. It doesn't protect you from the tool being wrong.
Correct. And if it does go wrong, say inaccurate AI content actually gets filed, the consequences sit with Clause 4.21. The court can disregard the material entirely, make adverse costs orders against you or your client, or refer you to the law society or bar association.
So the range runs from your evidence just doesn't count all the way to a regulatory referral.
That's the range, and a paid tool is not a defense to any of it.
Okay, I want to nail down what people should walk away and actually do differently on Monday morning.
3 things, actually. First, build the AI use log now, before you need it. Tool, task, verification, expert certifications. Doesn't need to be elaborate, just contemporaneous. Something you update as you go, not something you reconstruct from memory the week before a hearing.
Because reconstructing it after the fact is exactly when you forget half of what you actually did.
Exactly. And a log built after the fact looks a lot less credible than one built in real time. Second, if you're going to keep using public AI tools day to day, get in the habit of stripping identifying details before you type anything in. Every single time. No exceptions for just this once.
Not I'll de-identify it if it feels sensitive, but always.
Always, because what feels routine to you might identify a child or a protected party to someone reading the output later. Names, addresses, even quite specific fact patterns can be identifying in a small enough matter.
And the third thing?
Have the conversation with your firm, not just with yourself. If you're a principal, make sure everyone junior to you actually knows PDAI exists and applies to them too, not just to the tools you've formally rolled out, but to whatever they're quietly using on their own laptop.
Because a junior lawyer pasting a draft into their personal ChatGPT account is still your firm's exposure.
Still your exposure, and still squarely inside PDAI's scope, whether or not anyone in the office ever discussed it.
So if there's one line that sums up PDAI,
it's this. AI can help you draft it, but you're still the one who has to be able to stand behind it. That hasn't changed. PDAI has just made it explicit and given it teeth.
And presumably this is only version 1. Courts around the country are watching how FCFCOA's approach plays out.
Almost certainly, which is exactly why Clause 3.3F requires ongoing education proportionate to your AI use. This isn't a one-off box you tick, it's something you keep current on.
Definitely. Well, that's PDAI in 10 minutes. We hope this was helpful. Thanks for listening.
See ya. That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD page, linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.